हेलो, वेलकम यू ऑल टू लॉ सीखो। तो आज का जो हमारा पहला टॉपिक है दैट इज रिगार्डिंग द 14 क्वेश्चंस दैट वाज आस्क्ड बाय द प्रेसिडेंट to Supreme Court of India. So President Draupadi Murmu has invoked Article 143 Clause 1 of the Constitution for seeking the advisory opinion of Supreme Court. Now this particular advisory opinion that she seeks, it is regarding the recent case, the recent ruling that is given by Supreme Court on 8th April. The name of the case is Government of Tamil Nadu versus Governor of Tamil Nadu. So इसमें एक टाइम लिमिट सेट करने की बात करी थी फॉर द गवर्नर्स एंड ऑल्सो फॉर द प्रेसिडेंट इफ एनी बिल इज रिफर्ड टू द प्रेसिडेंट बाय द गवर्नर, दैट इज 3 months डेडलाइन। तो इसी को लेकर यहाँ पर प्रेसिडेंट ने क्वेश्चंस पूछ लिए, एडवाइजरी ओपिनियन को इन्वोक करते हुए 14 क्वेश्चंस पूछ लिए सुप्रीम कोर्ट ऑफ इंडिया को। तो क्या है ये आर्टिकल 143, कैसे पावर आता है ये एडवाइजरी जुरिस्डिक्शन का, ठीक है, इसके बारे में आज हम डिस्कस करेंगे। तो सबसे पहले देखिए व्हाट इज दिस आर्टिकल 143, दैट इज सुप्रीम कोर्ट्स एडवाइजरी जुरिस्डिक्शन। अगर इसका ओरिजिन देखें तो वी कैन सी द ओरिजिन इन गवर्नमेंट ऑफ इंडिया एक्ट ऑफ 1935 एंड एज वी नो कि मेनी प्रोविजंस ऑफ गवर्नमेंट ऑफ इंडिया एक्ट 1935 is also brought into or also borrowed by our constitution of India. Now what is the scope of this particular thing? So president may seek Supreme Court's opinion on any question of law or any question of fact, including any hypothetical or imaginary situation or any particular scenario. Now this particular thing, when it is invoked, if any question has arisen or is likely to arise and is of a public importance. So public importance should be a basic necessity for this particular thing. Now what is the procedure? The procedure is that कि this particular matter should be, अगर advisory opinion invoke होता है तो this particular matter should be heard by the bench of 5 judges. That is mentioned under article 145 clause 3. और यहाँ पर सुप्रीम कोर्ट जो है विल गिव देयर मेजॉरिटी ओपिनियन एंड विच विल नॉट बी बाइंडिंग ऑन द प्रेसिडेंट. अब now what is the purpose of this particular provision? The purpose of this provision is that कि we all know कि president work on the aid and advice of prime minister and council of minister. Now this provision actually enables the president to seek the independent consultation, independent constitutional advice from the Supreme Court also. If we see how many times this particular provision is used, it is used almost more than 15 times since 1950. So many times this provision invoked. This is not a new thing. Okay, now can Supreme Court decline this presidential reference? So the answer is yes. Article 143 clause 1 uses the word may. So it gives Supreme Court discretion to either answer or not. Now Supreme Court have already declined it twice. The two instances are, first instance is regarding the Ram Janmabhoomi reference. ठीक है, 1993 में ये मैटर सुप्रीम कोर्ट की एडवाइजरी ओपिनियन के प्रेसिडेंट ने इसे रिफर करा, लेकिन सुप्रीम कोर्ट डिक्लाइंड इट. व्हाई? बिकॉज दिस मैटर वाज सब जुडिस. नाउ 1982 में भी वी कैन सी दिस पर्टिकुलर थिंग रिगार्डिंग, दैट इज रिगार्डिंग द रीसेटलमेंट बिल रेफरेंस. तो जम्मू एंड कश्मीर से जो माइग्रेट हो गए थे उन्हें वापस यहाँ पर रिटर्न करने के लिए सुप्रीम कोर्ट का एडवाइजरी जुडिस्डिक्शन मांगा एंड सुप्रीम कोर्ट डिड नॉट आंसर एज द बिल वाज ऑलरेडी चैलेंज सेपरेटली. तो इस भी मैटर में हम देख सकते हैं कि द मैटर वाज द सब जुडिस मैटर. नाउ note this important thing कि this advisory opinion that is given by the Supreme Court to the President, it is not binding at all. Supreme Court अपना Supreme Court advice देंगे, this is also not binding, and the advice that is given, whether it will be binding on the President, the answer is no. ठीक है, so दोनों ही साइड से we can see कि this is the optional thing. Supreme Court generally decline this particular thing when it is regarding any particular political matter or it is a political sensitive matter. Okay, now can Supreme Court overturn its ruling that is given on April 8th, that was the state of Tamil Nadu versus the governor of Tamil Nadu case? So the answer is no, because Article 143 cannot be used to review or overturn the settled Supreme Court decision. Now we can see this example in Supreme Court's 1991 Kaveri opinion. Here advisory jurisdiction is not an appellant process. Supreme Court clarified this particular thing, and President cannot use Article 143 to revisit any particular judicial ruling. Supreme Court cannot sit in appeal on its own verdict via this particular reference. Then what is the alternative way? The alternative way is under Article 137, that is a review petition, and also there is the option of the curative petition if any miscarriage of justice happened. Now current context में we all know कि 8th April का the two judges bench division bench have given this particular ruling. Now this particular same kind of matters are also pending in the different high courts, ठीक है, or this kind of matter is there in the other states also. So there is a high chance that this matter will be further referred to the larger bench or the constitutional bench. So this is a possibility. Now here are these 14 questions that is asked by the president. You can pause the video and you can just go through. Very simple. It is all around the ruling that is given on the 8th April by Supreme Court in the case of state of Tamil Nadu, state of Tamil Nadu versus governor of Tamil Nadu. Okay, now let's move to our next topic, that is regarding YouTuber Jyoti Rani. So YouTuber Jyoti Rani, the famous travel vlogger, she's booked under the booked for spying under the Official Secret Act of 1923. Now first understand what are the charges that was against Jyoti Rani. Okay, so what happened first, we'll understand this particular thing. So this particular vlogger, she belongs to the state of Haryana. Okay, so now the allegation is that she was sharing the sensitive information related to India with Pakistan High Commission official. And one more thing, she was tasked with the promoting a positive image of Pakistan in India. So because of this particular thing, she was booked under section 3 and 5 of Official Secret Acts of 1983, that is regarding for spying and wrongful communication of secret information. And she is also booked under section 152 of Bharatiya Nyaya Sanhita, that replaced IPC, that is regarding acts endangering the sovereignty, unity and integrity of India. Now first we will understand what is this Official Secret Act. If we see the origin of this Official Secret Act, it is at the time of the British colonial era. So it is first enacted in year 1889 as the Act number 14 of 1889 for suppressing the dissenting press that was writing against the Britishers. Now in 1904, amendment happened in this particular act and it is became more stricter at the time of Lord Curzon. ठीक है, 1905 में we just see कि partition of Bengal was happened, and in 1923 the present version, ठीक है, the present current law, ठीक है, so the previous law was replaced by this 1923's version. So the current law, this is aimed to protecting the state's secret, especially in the matter of defense and national security. So if we see the key provision that actually punishes the spying, unauthorized access or disclosure of official document and threat to state security, okay, or nation security we can say. So first we'll understand what is this section 3, that is for penalty for spying. So it applies to any prejudicial to state safety, anything that is that actually threatens the state safety or dangers the state safety. So approaching or entering any prohibited place or making any sketch, note or plans useful to the enemy, okay, or collecting or communication or publishing any secret official information. This all things are covered under section 3. And what is the punishment under section 3? It is up to 14 years for the things that is related to defense and armed forces. Other things ke liye it is up to 3 years. Then section 5, it is regarding the wrongful communication of information. What it covers? It covers the unauthorized disclosure of official codes, plans and sensitive documents. Even if you are carelessly handling any particular sensitive information, official code or document, that time also you will be booked under this section 5. Now both giver and the receiver of this official of this secret info are liable, and punishment is up to 3-year imprisonment or fine or both. And there is one more provision that is of our Bharatiya Nyaya Sanhita, that is section 152, that talks about act endangering sovereignty, unity and integrity of India. So if you are purposely or knowingly, anyone who is purposely or knowingly excites or attempt to excite the secession, armed rebellion or any subversive activity or encourages any separatist feeling, act in a way that endangers our country's sovereignty, unity or integrity, and it can be in the form of spoken or written words, sign or visible representation, electronic communication, or use of financial news or means or any other method. So in that scenario, there will be life imprisonment or imprisonment up to 7 years and fine. There's only one exception to this particular thing, that is if you are doing any peaceful criticism or disapproval of government policy with lawful intent and which do not amount this offense. So these are the provision that was under that this Jyoti Rani is charged. So this is all for today. Thank you so much for listening me. Stay tuned to LawSikho.